All rise. We will obey.
Good morning again, everyone. So we're going to continue with this prosecution's submission on the defense's closing brief. The prosecution has 5 minutes more to do that, but we do take note that you have 60 minutes to give your to summarize your case. So depending on how you use your time, you have a total of 65 minutes for today's proceedings. Mr. Bifole, we listen to you.
Thank you, Your Honors. In my submissions, I will address the issues raised by the defense at paragraph 600 to 638 of the defense closing brief in relation to the mode of liability. In the submissions, the defense contend that direct co-perpetration as a mode of liability has no basis in the statute or the case law of the court. They also contend that circumstantial evidence is insufficient to prove a common plan. And they also contend that essential contributions cannot be made to the crime. And fourthly, they also contend that Said did not exercise effective command and control over the OCRB Seleka, and that intent and knowledge is not demonstrated. Your Honors, turning on to the first issue, at paragraph 600 to 602, the defense argues that direct co-perpetration as a mode of liability is a creation of the prosecution and that it has never been endorsed by the judges of this court. In the defense's view, this mode of liability has no basis either in the statute or the case law of the court. This is plainly incorrect. Mr. Said's submissions challenging his culpability for the co-perpetration are misdirected and should be rejected. Firstly, his challenge that the mode of liability of direct co-perpetration is a creation of the prosecution and that it offends the principle of legality is wrong. This mode of liability flows from the plain terms of Article 25(3)(a) and has been confirmed by the appeals chamber, including in the Onquen Appeal Judgment number 2022, paras 627, as read with 636 and 637. In paragraph 627, the appeals chamber deals with three forms of commission in Article 25(3)(a), one of which falls under the category of joint commission, in brackets, or co-perpetration, namely direct co-perpetration. The appeals chamber explained as follows. The appeals chamber, and I quote, the appeals chamber observes that the wording of Article 25(3)(a) of the statute is clear in that a person is considered a perpetrator when he or she, A, directly commits a crime as an individual, in brackets, direct perpetration, B, commits a crime jointly with another person, in brackets, co-perpetration, and or C, indirectly commits a crime, in brackets, indirect perpetration. In this regard, indirect perpetration refers to situations when the perpetrator uses another person as a tool to commit a crime. The provision clarifies in this regard that it is irrelevant whether or not the direct perpetrator is criminally responsible, him or herself. Your Honors, in that appeal judgment, The second form of commission, that is number B, is what the prosecutor in this case calls direct co-perpetration. Is what the prosecutor calls direct co-perpetration to refer to the same form of commission which the appeals chamber simply describes as commits a crime jointly with another person. The appeals chamber also distinguishes it from indirect perpetration, which it addresses as the third form of commission. Namely, indirectly commits a crime. In paragraph 636 and 637, the appeals chamber then deals with the fourth form of commission, namely indirect co-perpetration, which involves joint indirect commission of crimes, namely jointly using other persons to commit crimes. Therefore, direct co-perpetration is well established in the court's jurisprudence as a form of commission under Article 25(3)(a). Secondly, this mode of liability is directly reflected in Article 25(3)(a) of the statute itself. This provision provides expressly for criminal responsibility for a person who commits a crime jointly with another. That is, for co-perpetration. Since Article 25(3)(a) further provides also for responsibility for crimes committed through another person, there are thus two variants of co-perpetration. There are thus two variants of co-perpetration. That is direct co-perpetration, where contributions to the charged crime are made through the personal contact of the relevant perpetrator, and indirect co-perpetration, where contributions to the charged crimes are made by way of the co-perpetrator's use of other persons as tools. Your Honors, the statutory basis for both forms of co-perpetration is beyond question. Thirdly, the appeals chamber has already specifically rejected the defense claim that applying a normative approach to co-perpetration breaches either Article 22 of the statute or the principle of in dubio pro reo, and instead affirmed to the contrary that this approach is well known in international criminal law. Your Honors, I refer Your Honors to Lubanga Appeal Judgment, number 2275 at para 471. Moving on to the next issue, at paragraph 603 to paragraph 605 of the defense closing brief, the defense argues that circumstantial evidence without direct evidence is insufficient to prove a common plan. The defense further argues that the prosecution has failed to produce direct evidence, particularly with respect to meetings, instructions, and decisions involving co-perpetrators, and therefore the common plan has not been established. Firstly, co-perpetration does not require that the agreement or the common plan is explicit in order for the individual conduct of each co-perpetrator to be connected. Rather, the agreement or common plan can be inferred from circumstantial evidence. Although direct evidence of the common plan is one form of evidence that may show the existence of a common plan, this is not the only form of evidence legally required to do so. I refer Your Honors to the Lubanga trial judgment number 2842 at para 988. Secondly, and to the contrary, a common plan may be proven either directly or circumstantially from the concerted actions of the co-perpetrators or even with third parties, and the subsequent conduct of the co-perpetrators. I refer Your Honors to the appeals judgment number 2275 in the case of Bemba and 4 others at paragraph 764. Thirdly, there is no bar to a trial chamber using evidence to infer either backwards or forward in time an accused involvement in a common plan. And I refer Your Honors to the Bemba appeal judgment at para 1306. In this case, the prosecution has demonstrated that a common plan may be inferred from the concerted commission of the crimes as described at paras 124 to 303 of the prosecution closing brief. 2, from the actions of the co-perpetrators, including those of Said, such as arresting, detaining, and violently interrogating perceived Bosisi supporters at the OCRB as described at paras 124 to 303 and paras 304, 345 of the prosecution closing brief. And thirdly, from the subsequent conduct of the co-perpetrators at the SEDAT, including Adam, Tahir, and Dambucha, among others as described at paras 55, 72 to 75 of the prosecution's closing brief. The prosecution, Your Honors, has therefore demonstrated that Said and other co-perpetrators acted pursuant to a common plan, to which they made essential contributions with intent and knowledge. Turning on to the next issue, at paragraph 605 and 610 of the defense closing brief, the defense claims that the basis for listing the individuals as co-perpetrators in this case is unclear. In the defense's view, some individuals who ought to have been included in that list were wrongly excluded. This claim by the defense is unfounded. It is the prosecution, not the accused, that determines the scope of the charges for submission to the pre-trial chamber for confirmation, based on the evidence available to it. The basis for their inclusion in the list of co-perpetrators is the evidence demonstrating that they were members of a common plan and that with intent and knowledge, they made essential contributions to the common plan to target perceived Bosisi supporters in Bangi by committing the crimes charged in counts 1 to 7 at the OCRB as described at paras 124 to 303 and 304 to 345 of the prosecution's closing brief. There is no legal requirement that a common plan legally loses validity merely because some persons who may have been part of it are not named. It is sufficient that there is plurality of persons, regardless of their number, or whether every member is named, working in concert with the accused to perpetrate a crime. Indeed, like for joint common enterprise liability, it is not necessary to identify by name each of the persons involved, and depending on the circumstances of the case, it can be sufficient to infer to categories or groups of persons. I refer Your Honors to the case of Grudge Sneak Appeal Judgment, paras 156 and 710, and Stagic Appeal Judgment, paras 69. Your Honors, we submit that it is this common plan, express or implied, previously arranged or materializing extemporaneously, that ties the co-perpetrators together and that justifies the reciprocal imputation of their respective acts. I refer Your Honors to Lubanga Appeals Judgment at para 445. Turning on to the next issue, at paragraph 607 of the defense closing brief, The defense contends that essential contributions cannot be made to the crimes, rather implying that they can only be made to the common plan. That contention is incorrect. Essential contributions can be made at any stage of the criminal project, which means that it can be made at the planning, preparation, or execution stage. See Bemba et al. Judgment, paragraph 810, and Lubanga Bill Judgment, paragraph 473. A co-perpetrator can thus make essential contributions either to the crimes or to the common plan, depending on the circumstances of the case. The determining factor being that at whatever stage the contribution is made, it is made within the framework or pursuant to a common plan. I refer your honors to Bemba et al. Judgment, number 2275 at paragraph 812 and paragraph 824. Where the essential contribution is made to the common plan, for instance, at the planning or preparation stage, rather than at the execution stage, the appeals chamber in the Bemba case explains that the trial chamber is not required to make a finding that he has also made essential contribution to the crimes. I refer to Bemba judgment at paragraph 812 and 824. So, your honors, there is nothing in the court's jurisprudence that says that essential contributions cannot be made to the crimes. In this case, the prosecution has in its substantive submissions, particularly at paras 305 and 344 of the prosecution's closing brief.
Okay, just counsel, just so you know, you've used more than 16 minutes. Just so you're aware, because we shall not be using,
Yes.
giving up more time to
Thank you.
after your 60 minutes.
Thank you.
Thank
Thank you, Your Honors. Well noted here. In this case, the prosecution has, in its substantive submissions, particularly at paras 305 and 344 of the prosecution's closing brief, demonstrated that Said made essential contributions to the common plan. Consequently, we urge your honors to find that Said made essential contributions to the common plan. Your honors are now turned to the next issue. At paragraph 612 of the defense closing brief, the defense contends that the provision of food, weapons, or identification badges by Said to the OCRB Seleka does not, in the circumstances, constitute an essential contribution. They also contend that there is nothing illegal or abnormal about facilitating the provision of these things. Firstly, this assertion is incorrect, as it does not accurately reflect Said's essential contributions. The provision of food, badges, and weapons by Said plainly forms part of Said's essential contributions and cannot be dismissed as non-essential. Secondly, the essential nature of Said's contribution to the common plan is not solely established by the undisputed fact that he played a key role in the provision of food, identification badges, and weapons. Instead, it is founded on the entirety of the evidence relating to the contribution Said made as the highest ranking official within the OCRB. Thirdly, the defense submission that there is nothing illegal or abnormal, particularly about the provision of food and badges, is plainly wrong. Essential contribution may take many forms and need not be criminal in nature or made at the execution stage. Acts that do not, as such, form the actus reus of the crime or offense in question may nevertheless be taken into account when determining whether the accused has made essential contribution to that crime or offense. I refer your honors to appeals judgment, Bemba appeals judgment at para 810. Your Honors, I now turn to the next issue at paragraph 613, 615, 618 to 627 of the defense. The defense contends that Said should not incur liability for the crimes committed by the co-perpetrators, and in which Said is not mentioned. We submit that as a co-perpetrator, it is not necessary for Said to make an essential contribution to each criminal incident, provided that the incidents occur within the framework of a common plan, to which Said as a co-perpetrator made an essential contribution with intent and knowledge. I refer to paragraph 812 in the Bemba et al. Appeal judgment. On the next issue, Your Honors, the defense argument at paragraph 615 of the defense closing brief, the defense argues that the trial chamber should essentially disregard the evidence of some of the witnesses in relation to the abattoir torture method, simply because those witnesses do not specify the identities of the victims they are talking about. The prosecution submits that it is not necessary to prove the specific identity of the victim to prove that a crime indeed occurred. I refer Your Honors to the Bemba trial judgment at paragraph 88. On the next issue, the defense argues at paragraph 630 to 631 that Said did not have control or authority over the OCRB Seleka. It is our submission that at paragraphs 337 to 342 of the prosecution's closing brief, the prosecution has demonstrated that Said exercised effective command and control over the OCRB Seleka. Further, the fact that there were a few cases of indiscipline, as suggested by P0338, does not mean that Said's power and authority over the OCRB Seleka was diminished. P338's testimony should be considered cumulatively with the other evidence on record and not in isolation. And finally, turning on to the issue of intent and knowledge, at paragraph 636 to 638, the defense contends that the prosecution has failed to demonstrate Said's intention and knowledge. Your Honor, we submit that, as established in the court's jurisprudence, the mental element can be established on the basis of the totality of evidence, including, but not limited to, the accused position in the common plan and his role in and essential contribution to the commission of the crimes. I refer Your Honors to Al-Mahid Article 58 decision, para 177, and Pemba et al. Judgment, para 1308. And with that, I conclude my submissions and pass over the floor to Ms. Makwaya. Thank you.
Thank you very much, Counsel. Ms. Makwaya. You have about 41 minutes to summarize your submission on behalf of the prosecution.
Sorry, Madam President, I didn't have my headphones. How many minutes do we have remaining?
You have about 41 minutes. You end at 12:49.
Okay. Thank you, Your Honors, and good afternoon. I shall now begin summing up aspects of our case. And for those aspects, we will not be able to summarize before you because of time. We adopt our pleadings in the closing brief, Madam President, Your Honors. Madam President, during the course of the trial, you heard evidence that in late 2012, the situation in Kar was precarious and volatile, and intense combat or hostilities were taking place between the FACA and the Seleka coalition. For example, from P2091, the former Prime Minister, P2105. And on that, Madam President, we would like to show you the route that witness 2105 told the court he took, and subsequently other witnesses using the same map of Kar to demonstrate the descent into Sibut and then the attack of Bangui on the 24th of March 2013. Now, what we have before us, I'm trying to get it on my screen. No, that's too far away. Your Honors have before you now a map of Kar, and I will walk you through it. Now, you heard witness P2105, who testified before you that he joined a Seleka canal at Bria, transcript T-023, bracket 13-17. And during his evidence, you may recall, Your Honors, he annotated this map explaining the routes that the Seleka commanders took with their troops on their descent to Bangui. Can I please have the next slide? Now, P2101 left Bria, and then he went to Bambari. He traveled with his commander from Bria to Bambari, and he noted that other commanders had also left Bambari ahead of them to go to Sibut, while some were going through the bush and Grimari. P21 also recounted, Your Honors, that when the Seleka columns left Bambari, another column of Seleka with a different command left Cabo, and then another one, Kaga Bandoro. You can see it before you on the screen to the left, and then through Dekoa to go to Sibut. P2105 further testified that the aim of all these Seleka groups was to converge in Sibut, transcript 0223-17-18. At this time, he told you, Your Honors, that he was aware that government members had stayed in Sibut, and some Seleka leaders were also there, as well as members of the government, as I've stated. He also explained in his testimony that there were South African troops, the CEAC, stationed at Damara. He told you, Madam President, they were stationed at Damara because there was a red line that demarcated the separation between the government troops and the Seleka troops, what was then known as the red line of Damara, and you can see it on the map. He also told you that intense fighting on the night of the 23rd of March took place as the Seleka tried to push forward to Bangui. Another witness who gave evidence on this is P0342, an overview witness, Madam President, Your Honors. You would recall his extensive evidence and his involvement. For identification reasons, I will not go any further. 342 told you that the Seleka went through different provinces of Kar and of the political negotiations of senior members of the Bozize government and the Seleka at Sibut. Before you, Madam President, you do have here, and according to the evidence on record, as spoken to by 342, you do have here a picture of the former president with the red scarf, Mr. Joe Todia. And to the right, you have Mr. Nuruddin Adam with the green scarf.
Can it be shown to the public?
Yeah. Sorry. Yes, of course. P3042 also told you, Your Honors, at this point in Damara, the Seleka were amassing. They were meeting up. They were grouping. The witness also recounted that once the Seleka also recounted how the Seleka entered Bangui through various roads coming via Damara, by the Damara Road, the Boali Road, the Mbaiki Road, and also on foot through the hills, transcript 123, culminating in the Seleka attack on Bangui of the 24th of March. Other relevant witnesses to this aspect of the evidence, Your Honors, are P1167, P0291, P1263, 2563, 2240, and 0338. Each of these witnesses corroborated a section reflecting their personal interaction with the Seleka army as they moved through the provinces to attack Bangui. What you have before you now, Your Honors, is a select, I think the defense is issued.
Are you fine now? Your mic is not on, so I can't hear you.
Ms. Nori,
Mais ça va beaucoup trop vite. On n'a pas.
it's far too fast. We have nothing on the transcript. I'm very sorry about that, but nothing on the transcript.
I'm running against time.
Yes, but you have, we need the transcript, and they'll need the transcript to respond to you tomorrow, so.
So where shall I take it up again from? Would you like me to repeat?
Alors, on n'a pas du tout la.
We do not have the pseudonyms, so the list of pseudonyms that you just gave, if you could just actually repeat that, that would be really great. Thank you.
They'll pop up in a minute as well on the screen, but I'll do that. So the pseudonyms are 1167, 0291, 1263, 2563, 2240, and P0338. And I had just stated, Your Honors, that each of these witnesses corroborated a section reflecting their personal interaction within the Seleka army as they progressed through the provinces to attack Bangui. Now, starting with 1167, a Seleka insider. He told you about the coordination of the Seleka routes leading into Bangui. This witness joined the Seleka Canal in Sibut and was told while he was on the access to the Koa, because he'd left Sibut for the Koa, to go back to Sibut because Michel Jotodia was going there, and that a meeting with all Seleka officers was going to take place. Transcript T34-P57.23. He also stated, Your Honors, that the decision was made to descend to Bangui to take power subsequently. Transcript -34, P43, 9. Additionally, he stated that another Seleka section or column was to go to Bwaka, Bosangoa, and Bosembele, while the second section was to go from Sibut to Bangui via Damara. The witness stated, and I quote, Bwaka had fallen, Bosangoa had been attacked, and the section which had attacked Bosangoa was moving on to Bosembele, and that section was moving on to Bosembele. This witness, who's an insider, as I've stated, Madam President, also testified that there was a certain amount of resistance at Damara. There was fighting. Transcript -34, P43.22. While there, he heard that another group had left Bambari with their commander also on their way. While there, he also witnessed some FOMAC, Chadian contingents, giving ammunition or munitions to the Seleka. He also heard that the South African soldiers were blocking the route to Bangui. This meant the Seleka, or some Seleka, had to go via Lando and Boali in order to arrive in Bangui on the 24th of March, transcript T34, P65. The former Prime Minister of Car also appeared before you, Your Honors, and he provided evidence on the meeting with Jotodia in Sibut. He told you of the intention of pacifying the Seleka and restricting their movements. But the Seleka had issued a 72-hour ultimatum to the Bozize government, and if their demands were not met, they would take arms again. Transcript -061, English version at 31.1-33.15. The Prime Minister also explained that there were two fronts at this point on the Damara Road and another battle on the Bosembele Road. He confirmed that the fighting culminated in the Seleka overthrowing the government of Bozize on the 24th of March. A crime-based witness, P1263, was also in Sibut, and he could not travel because the Seleka had arrived at Damara, where there was a red line, so there was a blockade, so he could not move. He testified because of this red line, they were stopped from going into Bangui. Madam President, Your Honors would recall the evidence that it wasn't just the Seleka who was barred from crossing the red line at Damara. This also applied to the Faka army. They could not go into the Seleka zones. At this point, Madam President, Your Honors, the evidence on record demonstrates Ka was cut almost into two, with the red line separating the two belligerents, the Seleka occupying the northern part and the Faka government or pro-Bozize forces to the south. The witness also recalled that the Seleka came in vehicles by way of Bambari Road and by the Bandoro Road in Sibut. P1263 noted that the Seleka had vehicles and were armed with weapons and were wearing military uniforms. Transcript T0104 English at page 31. Now turning to P2563, a Seleka insider also gave evidence on the movement of the Seleka and the conversion of the Seleka at Sibut and the red line that stopped them from going beyond. He went there with the Seleka commander he had arrived with from elsewhere. He also spoke about the negotiations that were taking place in Sibut and the meeting between the Seleka chiefs and commanders, including Jotodia, because he was present there for more than 3 days, Your Honors. P224, an official. P224, another crime-based witness, gave similar evidence of the events in Sibut and the failure of the mediation between the Seleka and the coalition of the Bozize government. The failure of the negotiations led to the Seleka crossing the red line at Damara, as stated by the witness at T032 of the transcript, CAR OTP 2107 8860-RO2 at 8863-8864, paragraphs 13 to 15. Another insider, Madam President, P0338, recounted a similar situation of the coalition Seleka forces meeting at Sibut, coming from different zones. He also spoke about the red line to you and other members of government who had subsequently left Sibut to return to Bangui. Now, that, Madam President, concludes this aspect on the Seleka and the war crimes and refutes the assertions of the defense that it was chaotic, it was a coalition of circumstances, it was all impulsive on the side of the Seleka. It was not. There was clear organization, different Seleka columns and sections converging in Sibut before the planned attack on Bangui, ousting President Bozize on the 24th of March. At this stage, Your Honors, I'm going to call on Ms. Ndagire to submit to you on the persecution.
Thank you very much, Counsel. Ms. Ndagire, please.
May it please the Court, in my very brief submissions, I will address count 7 of the crime of persecution charged against Mr. Said, and after that I will speak to the inhumane detention conditions that people were subjected to at the OCRB. The prosecution has proved beyond reasonable doubt that during the charged period, Mr. Said, other senior Seleka members, and OCRB Seleka targeted for attack men in Bangui who they considered supporters of Francois Bozize. Mr. Said and his co-perpetrators did so pursuant to the Seleka's state or organizational policy, which was devised by the Seleka and executed by its government officials and elements. The targeted men did not need to show overt partisanship. It was enough that they resided in neighborhoods perceived to have been associated with Bozize, specifically Boyrab in the 4th arrondissement and the 7th arrondissement. It was sufficient that the men were of the Christian faith and were of the Baya, Manja, and Banda ethnic groups, all of which the Seleka perceived to support Bozize. It was also sufficient, Your Honors, that the men were former FACA or members of the Presidential Guard when Bozize was President of the Central African Republic, or that they worked for him in other functions during that time. Mr. Said endorsed this persecutory campaign through his own words and actions towards the men detained at the OCRB. He personally handcuffed witness P3056, placed a plastic hood on his head, and interrogated him for 2 to 3 hours about his ethnicity and alleged connections with Bozize, and about a member of the Anti-Balaka. This was a transcript T20. Mr. Said personally interrogated and threatened witness P2692 nearly every day for the almost 3 weeks that he was detained at the OCRB to establish if he was related to a member of the Anti-Balaka. This is at paragraph 31 of that witness's statement. Mr. Said's co-perpetrators at the OCRB also endorsed the persecutory campaign through their own words and actions to the men detained at the OCRB. For instance, witness P1743 testified at transcript 87 that as the OCRB Seleka whipped his bare back, which they covered with sand and water, they said to him, and I quote, "You there, you and Bozize, you reigned for 10 years, and what did you do that was good for the country? You reigned alongside Bozize for 10 years, and what did you do that was good in any way to dare to drive us out? Witness P0481 at transcript 72 testified that Nuruddin Adam, Mr. Said's superior, interrogated him regarding his association with Bozize, and that the OCRB Seleka then severely beat and burnt him with hot plastic. Witnesses P0547 and P0622 confirmed that to the Seleka, perceived Bozize supporters were animals and mercenaries who they were going to kill. Witness P0622 and his colleagues were harassed on account of where they worked and were referred to by the OCRB Seleka as les gens de Bozize. The evidence and testimonies summarized at paragraphs 130 to 250 and 259 of the prosecution's closing brief show that most of the men who were subjected to the charged crimes were of Baya, Manja, and Banda ethnicity. The evidence summarized at those same paragraphs of our brief also show that at least 15 of the men who were subjected to the charged crimes were Christians. Witness 2692 relayed in paragraph 20 of his statement that he overheard the Seleka, whilst taking him to the OCRB, blame Christians for having ruled the country for 50 years. This sentiment was also echoed by Michel Jotodia, then president, according to the testimony of witness P0291. The evidence and testimonies summarized at paragraphs 57 to 64 and 296 to 297 of our closing brief, all confirm that in April and August 2013, the Seleka targeted for attack the residents of Boirab in the 4th arrondissement and those of the 7th arrondissement because former FACA or members of the Presidential Guard lived there. The Seleka's disdain for these neighborhoods is also evidenced through the dehumanizing language that the Seleka used to refer to the residents of Boirab during these attacks. A witness recounted how Mr. Said's superior, Nuruddin Adam, warned Boirab residents to stop with their stubborn behavior and said, quote, unquote, "If they don't stop one day, I will burn this neighborhood." Another witness recalled that a Seleka commander named Kondo warned Boirab residents that if the culprits who fired shots at the National Assembly during Mr. Jotodia's inauguration did not come forward, quote unquote, the lizards will be confused with the trees. A meaning that was civilians would be attacked along with the military. This was at paragraphs 43 to 44 of statement Caro TP 2074-2965. Seleka soldiers also told Boirab residents that they were of less value than chicken. It is irrefutable, Your Honors, that none of the witnesses' testimonies and accounts in paragraphs 130 to 250 in our brief who were detained at the OCRB, nor those who were attacked during the Seleka operations in April and August of 2013 took part in any hostilities. Mr. Said and his Seleka co-perpetrators systematically targeted the men they subsequently detained at the OCRB during the charge period, persecuting them on intersecting political, ethnic, religious, and gender grounds. The intersectional nature of discriminatory targeting is acknowledged by this court in paragraphs 787 and 936 of the trial judgment in the case of Prosecutor versus Abdul Rahman. We invite this honorable chamber to make a similar finding to Abdul Rahman and convict Mr. Said for the crime of persecution committed against the people who were detained at the OCRB during the charged period. I now turn to the inhumane detention conditions that the people held at the OCRB were subjected to. The multiple testimonies and documentary evidence before your honors establishes that detention conditions were deplorable. Detainees were cramped into dark, hot cells in the compound or courtyard of the OCRB, and others were detained in a dark and filthy underground cell beneath Mr. Said's office in the main building. The evidence summarized at paragraph 257 of our closing brief establishes that at least 25 men were detained in the underground cell that you now see on your screens to the left throughout the charged period. Witnesses P3056, P3053, P3064, and P2400 at transcripts 20, 30, 74, and 75, all testified about their lived experiences having been personally detained in this underground cell at the orders of Mr. Said. Witnesses P2179, P2400, P3056, P3064, and P0547 described that the underground cell beneath Mr. Said's office was dark and filthy, infested with cockroaches, lizards, human excrement, and had an unbearable smell. Not only does this underground cell symbolize how Mr. Said and the OCRB Seleka severely deprived the liberty of the people they detained at the OCRB, it is a stark reminder of Mr. Said's close proximity to the charged crimes, which he cannot convince a reasonable chamber he was unaware of. The evidence before you shows that while Mr. Said was in charge of the OCRB during the charged period, people detained there did not receive medical attention. During his detention, witness P2400 did not receive any medical care from Mr. Said or the OCRB Seleka for the bruises and bleeding head injury he sustained while being held at another Seleka base in Bangui. Witness P0547 was tortured and cruelly treated by the Seleka at the OCRB over whom Mr. Said had command. The OCRB Seleka later mocked 0547 because he could not physically get out of the underground cell due to the severity of his injuries. Your honors heard evidence that detainees in the underground cell could not leave or get out at will. Witness 547 recalled how on one occasion he and his co-detainees negotiated with the Seleka guarding the underground cell to let them out in order to have something to drink or take medication. On that occasion, the Seleka permitted the detainees to come out because Mr. Said was not at the OCRB. But when Mr. Said returned and found the detainees outside, he instructed them for them to be returned to the underground cell immediately. And this was in the testimony provided in transcripts 13 and transcripts 16. The conditions in the cells within the OCRB courtyard were equally dismal, Your Honors. Witness P0622 recounted that the cell he was detained in was overcrowded, such that it was impossible to lie down on the ground. Witness 2692 recounted in order to sleep, detainees in his cell had to lie on their sides, head to toe, and take turns with those that were sitting on the ledge along the wall of the cell. This is at paragraph 29 of his statement. Witness P2263 recounted that there was no water or place to relieve oneself inside the cells, and that the toilet outside was full of feces. The OCRB Seleka gave P2263 and his co-detainees empty water bottles in which to urinate. Witness P0481 testified at transcript 72 that the OCRB Seleka bound his hands for the first 10 days he was detained at the OCRB. His hands then remained bound while he slept, and even when he needed help from another detainee to ease himself in a bucket within the cell where he was detained. This is a transcript 72, pages 31 to 33.
You have about 10 minutes more, counsel.
Thank you. The evidence on record establishes that the detainees at the OCRB were not provided with adequate food or water. Witnesses P1429, P2931, P3056, P3064, and P2337 told Your Honors that some detainees at the OCRB relied on their families to provide them with food. However, witness P0622 and his cellmates had no choice but to drink their own urine in order to survive and avoid dying of thirst. This was relayed by the witness at paragraphs 59 and 62 of his statement. The evidence establishes that witness P2241's right to liberty was violated on account of her detention at the OCRB for 2 weeks on no charge made known to her. Despite her poor health and medical condition, witness P2241 was not provided any medication by Mr. Said or the OCRB Seleka for the duration of the time she spent at the OCRB. And despite her family paying a ransom to Mr. Said, witness P2241 was not released. I refer Your Honors to the English transcript of the witness at transcript 48. Witnesses P3056, P3053, P3064, P2400, P2179, P0547, P0622, P2692, P2263, P0481, P1429, P2931, P2337, P2241, and P2339 all gave credible, reliable, and coherent accounts about how dire and inhumane the detention conditions at the OCRB were from their own observation and or lived experience. They all confirm that the conditions were not fit for human beings, depriving them of their most basic rights and subjecting them to severe physical and mental suffering. This chamber must therefore find Mr. Said guilty in respect to count 1 on the premise of his role at the OCRB, his participation in and proximity to the crime of imprisonment or the severe deprivation of liberty of the aforementioned people who were detained at the OCRB. I now invite Ms. Makwaya to to provide our concluding remarks. I thank you.
Thank you very much, Council. Ms. McQuire, please. You have about 5 minutes to conclude.
Thank you, Madam President, Your Honors. From the evidence led, from the 81 witnesses presented before you, it is incontrovertible, Madam President, that Mr. Said was at the OCRB, was a Seleka Colonel, was the de facto leader at the OCRB between April and August 2013, when it was disbanded. It is also incontrovertible from the evidence led, Madam President, Your Honors, that at the OCRB, individuals were held, they were detained in an arbitrary manner without due process. Similarly, Your Honors, it is incontrovertible, in the very proximate of Mr. Said's office, there was an underground cell. Ms. Ndagire just showed you some of the slides where people were held and treated in the most abhorrent of manners. The evidence also shows, Madam President, Your Honors, that Mr. Said was in full command, was in full control of the OCRB when he led it. He was not a mere volunteer. He was not a mere support staff, as the defense of Mr. Said would have you believe. Having said that, Your Honors, we thank you for listening to our submissions today and respectfully request that you find Mr. Said guilty of the charged crimes from count 1 to 7. The prosecution has the onus, the prosecution has the burden to prove its case beyond a reasonable doubt, and it is our submission we have done so. Thank you, Madam President, Your Honors. We remain available for any questions.
Thank you very much, Counsel, and thanks to the prosecution team. With the accommodation of the registry and, of course, the defense, we're going to ask Ms. Pele to make your own submission on behalf of the victims of the crimes as charged. Ms. Pele, please.
Merci.
Ms. Pele, thank you, Your Honor. Madam President, Your Honors. Today, we speak on behalf of 32 victims. We have had the honor and the responsibility of representing these people throughout the entire trial, and more generally speaking, we have been the ones who gave a voice to those who suffered in silence for more than 12 years. These victims have been waiting for this moment since the year 2013, whether they are participants in these proceedings or whether they were excluded. The lives of these women and men were broken forever within the OCRB, the Central Office for the Repression of Banditry, under a facility that was under the control of the Seleka and the accused person, Mohamed Said Abdel Khani. The victims have waited for more than a decade for their voices to be heard. They await the truth. They await recognition. They await justice. These victims were not combatants. They were not criminals. They were mere civilians, mothers, fathers, students, arrested, tortured, and in some cases killed, merely because they were perceived as opponents to the regime that emerged when the government was overthrown on the 24th of March 2013. What had they done wrong? They had merely lived in Boyrab, or they were from the Baya ethnicity, or they were Christians. They wore a FACA uniform. They had worked under the government that had been overthrown, or they were suspected of having been linked to the writing or distribution of leaflets calling for Jitoja to step down. Or perhaps they had just been in the wrong place at the wrong time. Allow me to remind the bench of the fundamental role of victims before this court. Article 68(3) of the Rome Statute grants them the right to take part in proceedings when their personal interests are involved. This right is not incidental in nature, nor is it symbolic. It is essential. It lies at the very heart of this court's mandate. The victims are not mere spectators watching a criminal trial unfold, nor should they be. They are not a second prosecution either. They have their own voice, a unique perspective. One cannot challenge their legitimacy. Their participation is a vector of truth, justice, and reparation. Their participation could have allowed you to understand the crimes in all their humanity, in all their complexity. Yet in this case, you reduced their role to a mere formality. You adopted an overly restrictive approach, restricting their participation to the sole incidents mentioned in the decision confirming the charges. Yet, the participation of victims before this court is not a privilege that is granted depending on the circumstances. Rather, it is a fundamental right that must be exercised with dignity, in a respectful way, and with consistency. You excluded victims, even ones who had been detained at this OCRB during the period of time covered by the charges. Some had been arrested and mistreated by the accused person himself. Others had been participating victims, but then their status was withdrawn, even though their credibility had not been questioned. This approach, your approach, Madam President, Your Honours, deprived these proceedings of a wealth of information, testimony from what the victims experience and their contribution to the search for the truth. And yet, even though the victims have been set aside, they still believe in this court. They hope that you will hear their voices. They hope that you will recognize their suffering. They hope that you will render justice. And they hope, once again, that ultimately, one day, finally, they will have the opportunity for their voices to be heard. Mr. Dibert-Bécoy will now continue with a summary of the victims' views and concerns.
Lors d'une récente mission à Bangui,
During a recent trip to Bangui, the victims who took part in these proceedings expressed their expectations, their ongoing suffering, and their wishes for the judgment to come. Despite the diversity of what they went through, one single message comes through clearly. They want to be heard. They want to be recognized. They do not wish to be forgotten. Some have stressed just how important it is for the chamber to take into account the reality of what they experienced. Victim A70-29722, quote, "It's important for the judges to remember what the victims experienced when they retire to come to a decision. Other victims stressed that their suffering was not limited in time or by the legal boundaries of this particular case. Victim A70-303-22 said this, "I'm alive, but the suffering continues," whereas victim A70-294-22 has said, "The victim's health is deteriorating as the years have gone by." Several victims have expressed their deep disappointment in light of the limited scope of this case. They feel as though an imperfect form of justice is being handed down because other crimes committed by the accused person were not looked at. For example, victim A300-0422 said, and I quote, "The victims were forgotten and those who were guilty have been rewarded." Victim A70-29922 added this, quote, "I want some kind of calm. I want to achieve quiet, calm, thanks to the accused person being found guilty." The victims were the ones who experienced the reality of what happened. They truly hope for justice to be done so that an example is set for other criminals. Many victims are still living with the psychological damage of the torture and the violence and the terror that the accused person imposed upon them. Witness A70-290-22 said this, quote, "I remember the torture I was subjected to. I feel uncomfortable with the past." Victim A70-311-22 said that he becomes agitated each time he thinks back to the events. Other victims, for example, A70-293-22, stress that, quote, "The suffering of victims must be recognized. This suffering cannot be forgotten," end of quote. And several victims had specific views about the role of the accused. Victim A70-313-20 said quite clearly, "Saeed hit me. He can't be acquitted. That would be impossible." Victim A70-298-22 said, in relation to the barbaric acts that were perpetrated upon him, he said this, "The accused must realize what he did," end of quote. And finally, victim A360-22 has summed up the viewpoint of many, quote, "The accused should walk in our shoes. We are human beings. We're not animals," end of quote. And behind each account from the victims, we find a path of resilience, and often this is a lonely path. Victim A70-28922 expressed the pain of having to live alongside the people who persecuted him. Quote, "We are trying to live with our enemies. Every day we bear the burden of the torture that we were subjected to. It is very important to recognize our status as victims." Victim A70-299-22 said this, "I want justice to be done. I trust the court to render justice." And he said this despite all the injuries. He still had a few glimmers of hope for justice. Ms. Pellet shall now continue. Madame Pellet. The evidence that has been brought before this court is staggering. It is specific, consistent. The evidence has been corroborated. The evidence speaks to a systemic campaign of terror orchestrated by the Seleka and carried out under the command of Colonel Mahamat Saeed Abdelkani at the OCRB. In the past, the OCRB was an institution for law enforcement. Under Mr. Saeed, it became a torture site where civilians were detained arbitrarily, beaten, tortured, and killed. Madam President, Your Honors, chaos did not reign at the OCRB. Mr. Saeed was there every day. He checked what was going on there. He held meetings. He gave orders. He approved torture. He watched as people were beaten up. He collected the ransoms. He was not just a spectator. He was the man who built the suffering inflicted upon the victims. He was the architect. The defense has attempted to place doubt in your minds, but speculation is not the same thing as doubt. The defense have not challenged the essential events. The defense have not adduced evidence to refute the crimes. The defense merely focused on a political interpretation of the Central African Republic and the context there at the time of the events. The defense looked through a Western lens and focused on the personal path of witnesses. But the truth remains. The victims were detained. They were mistreated. The victims were tortured. The victims were killed. And Mr. Saeed was the one running the show. The evidence demonstrates that these actions were not some kind of isolated behavior by subordinates who had run out of control. They were part of a system, a policy of control through terror. The OCRB was an essential part of the Seleka's domination over Bangui. And, I stress, the OCRB was commanded by Mr. Saeed. Madam President, Your Honors, the restrictive approach taken by the Chamber in relation to the participation of victims has been deeply painful. For many victims, many victims have been excluded despite clear-cut links to the crimes. Their voices have been silenced. People have ignored their suffering, and yet they still believe in this court. They still believe in you.
Les victimes que nous représentons
The victims we represent are not calling for revenge. They seek to understand. They want to know why they were arrested, beaten, tortured, humiliated, why their loved ones were abducted or executed, sometimes before their very eyes. The victims want the dignity stolen from them at the OCRB is finally restored to them here in this courtroom, in your judgment. The victims want that their children can live in peace. They know justice will not erase their pain, but they hope it can at least give it some meaning. Madam President, Thijs van Lietsenburg will continue, so I'll give her the floor now.
Madame la Présidente,
Madam President, Your Honours,
les crimes commis à
the crimes
l'OCRB
committed at the
n'étaient pas
OCRB
des crimes isolés.
were not isolated crimes.
Ils s'inscrivaient dans un
They
plan
formed part of a
coordonné,
coordinated plan
exécuté avec intention.
executed intentionally.
L'ascension de la
The
Séléka
rise of the
s'est
Celica
faite par la violence.
was built through
Leur pouvoir
violence.
s'est bâti
Their
sur la
power
peur.
was built on fear.
Les preuves démontrent
The evidence shows
l'existence
the
d'une
existence
politique visant
of a
à cibler
policy
les civils.
aimed at targeting civilians.
Les victimes ont souffert
The
physiquement,
victims suffered physically,
psychologiquement,
psychologically,
matériellement.
materially.
Comme l'a rappelé Maître
As
Didier,
recalled by
elles vivent
Counsel
avec des
Diber
cicatrices,
Bekoy, they live with
des
scars,
traumatismes,
trauma,
des pertes.
and losses.
Elles ont perdu leur
They
maison,
lost their homes,
leurs moyens de
their
subsistance,
livelihoods,
leurs proches.
their loved ones.
Elles ont été
They
humiliées,
were humiliated,
stigmatisées,
stigmatized,
oubliées.
and overlooked.
Mais aujourd'hui,
But today,
elles sont là,
they are here,
debout,
standing,
et elles vous demandent
and they
une
ask
chose,
you one thing,
la reconnaissance.
recognition.
Elles vous demandent
They ask you to declare
Mohamed Saïd
Mohammed Saeed Abdel Khani
coupable de tous les chefs
guilty
d'accusation.
on all counts.
Madame la Présidente,
Madam President,
Madame et Messieurs les juges,
Your Honours,
la justice
Justice
ne se limite pas à la,
is
à la
not
sanction.
limited to punishment.
Elle est aussi porteuse
It
de
also
reconnaissance.
carries
Elle est
recognition with
porteuse
it.
de dignité.
It brings dignity.
Elle est la
It
garantie
is a guarantee
que ce qui s'est passé à
of what
l'OCRB
happened at the
ne se
OCRB
reproduira plus.
will never happen again.
Les victimes ont
The
fait leur
victims
part.
have done their part.
84%
84%
d'entre elles ont
of them
témoigné.
have testified.
Elles ont revécu
They
l'horreur.
have relived the horror.
Elles ont fait confiance à cette cour
They have put trust in the
en mettant
court.
leur douleur entre
They have
vos mains.
placed their pain in your hands.
Les témoignages
The
convergent.
testimonies
Les
converge.
conditions de détention
The detention
à l'OCRB
conditions at the
étaient
OCRB
inhumaines.
were inhuman.
Les détenus étaient
Detainees
entassés
were
dans de
crammed
petites cellules,
into tiny cells
sans lumière,
without light
aération.
or air,
couchés à même le sol
lying
de ciment,
directly on a cement floor,
privés d'eau
deprived of water,
nourriture.
food,
et de soins.
and medical care.
Beaucoup d'entre eux
Many
ont dû se
had to
soulager
relieve
dans des
themselves
seaux
in
qui
buckets,
vidaient chaque matin
emptied each
sous
morning
la surveillance
under the
soldats armés.
watchful eye of armed soldiers.
Certains ont décrit la faim,
Some described hunger,
la soif,
thirst,
la puanteur
stench,
et le désespoir.
and despair.
D'autres ont parlé de
Others spoke
de la peur constante,
of the constant
de
fear
l'impossibilité
and the
de dormir
impossibility of sleeping
parce qu'ils savaient que
because they
chaque
knew
nuit,
that each
un
night
détenu
a
serait
detainee would be
emmené pour ne
taken
jamais
away
revenir.
to never return.
Les sévices corporels étaient
Physical
quotidiens.
abuse was daily.
Passage à tabac,
Beatings,
coups de crosse,
rifle butt
Brûlures.
blows, burns,
menottes serrées jusqu'au sang.
handcuffs tightened until they bled.
Parmi les méthodes les plus
Amongst the
atroces,
most atrocious
figure celle
methods
dite arbatasa,
was the so-called
au
abacha,
cours de laquelle
in
les
which
bras
the
et les jambes
arms
des
and
victimes
legs of the
étaient
victims
liés derrière leur dos
were tied behind their
jusqu'à
backs
ce que leurs membres se
until their
disloquent,
limbs were
pour entraîner
dislocated,
l'arrêt rapide
which led
de la circulation
to a
sanguine,
stop of blood
entraînant
flow
ainsi
and
la
resulting
paralysie
in
des membres.
a paralysis
Et cette
of the
méthode,
limbs. This method,
Importée par la
imported
Séléka,
by the Celica,
était pratiquée
was
avec la
practiced
bénédiction,
with the approval,
sinon sous le regard.
if not under the
de l'accusé.
direct gaze, of the accused.
Les victimes ont fait leur part.
The victims have done their part.
Et c'est maintenant à
Now
vous
it is your
de faire
turn
la vôtre.
to do
Madame la
yours,
Présidente,
Madam
Madame et
President,
Messieurs
your
les
honours.
Les victimes ne vous demandent pas
The victims
l'impossible.
are not asking for the impossible.
Elles ne demandent pas que le
They're not
passé soit
asking
effacé.
for the past to be erased.
Elles demandent
They
simplement
simply ask
qu'il soit reconnu.
that it be acknowledged.
Les victimes savent
The
que la
victims
décision
know that
qui
the
sera
decision
rendue
belongs
appartient à la Chambre.
to the chamber,
Mais elles espèrent
but they
que
hope
ce jugement
your judgment
reflètera
will
la
reflect
vérité de leur
the
vécu
truth of their
et
experience,
qu'il sera porteur
and
d'un message
it will
clair,
send a clear message,
celui que la dignité humaine
that is, human
ne peut
dignity
être impunément
cannot
piétinée,
be trampled upon with
où que ce
impunity,
soit,
regardless of where it is in the world
Et
or
maintenant,
by whom.
Sarah Pellet va conclure ses
And now
observations
Sarah
finales,
Pillay
faites
will
au nom des
conclude our final observations on behalf of the victims.
Madame la Présidente, Madame et Messieurs les
Madam
juges,
President, Your
nous
Honours,
soumettons respectueusement
we humbly
les éléments de
submit
preuve
that the evidence establishes beyond reasonable doubt the criminal responsibility of Mohammed Saeed
Monsieur Mahamat Saïd
Abdel Khani
pour les crimes
for the crimes charged.
les victimes
The victims
demandent de le déclarer
ask you
coupable
to find him guilty
des chefs d'accusation.
for all counts,
Mais elles vous demandent également
but they also ask you
de prendre
to fully
pleinement en
consider
compte les préjudices
the
qu'elles ont
harm
subis.
that they have suffered.
Les crimes
The
pour lesquels
crimes for which the
l'accusé
accused
est jugé
is
ne
tried
que quelques mois
only cover a few months,
seulement,
only
d'avril à
April
août
to
2013.
August 2013,
Mais leur souffrance,
but their suffering
perdurera toute leur
will
vie.
last their entire lives.
Leurs blessures,
Their
qu'elles
injuries,
soient visibles,
be they visible or invisible,
échappent, en effet,
escape
au calendrier judiciaire.
the constraints of a judicial calendar.
Madame la Présidente,
Madam President,
Madame et Messieurs les juges,
Your Honours,
il n'existe pas de petites
there are
affaires
no
devant cette
small cases before this court.
ni les limites
Neither
temporelles,
temporal
géographiques
nor
d'un
geographic limits,
dossier, ni le nombre
nor the
de
number of
victimes
victims
autorisées à
admitted to
participer
participate
ne peuvent
can
réduire cette
take
importance.
away from its importance.
Chaque victime
Each victim of crime
relevant de la
within
compétence
this
de
court's
l'action
jurisdiction
porte en elle la
carries
trace d'un monde brisé.
the traces of a broken world.
Elle nous rappelle
They remind
que la
us
justice
that
internationale
international
pénale
criminal
ne
justice
se mesure pas à la quantité,
is not only measured or is
mais à
not
la
measured by
profondeur
quantity,
de
but
la
rather
douleur qu'elle
by the
reconnaît
depth of
et
pain
qu'elle s'efforce
it
de réparer.
recognizes and strives to repair.
Certaines victimes
Some
ont
victims
confié,
confided,
comme nous l'avons rappelé,
as we have
leur
already
peine
told you,
et
that
constaté
sorrow,
qu'une
that
partie de
parts
ce qu'elles avaient
of what they
vécu
lived
n'a pas
through
pu être examiné
could not
par
be
cette
examined by this court.
Elles comprennent
They
les
understand
contraintes juridiques,
the legal
mais
constraints,
elles ressentent au plus
but
profond
nevertheless,
d'elles-mêmes
deep down inside, they feel that their story remains incomplete until all the crimes
toute la
and
douleur,
suffering they endured
douleur qu'elles ont endurée et qu'elles
are
endurent encore aujourd'hui.
acknowledged, and they continue to suffer today. This needs to be acknowledged.
Enfin,
And finally,
les victimes souhaitent
the victims wish that this judgment, your judgment,
soit un message à tous ceux
sends
qui pensent
a
pouvoir
message to
torturer
all those who
et
believe
tuer
that
en toute
torture
impunité,
and killing with impunity
qu'ils
is
soient un
acceptable.
pas vers leur guérison.
This will be a step towards their healing.
Cela conclut, Madame la
This
Présidente,
concludes,
Madame
Madam
et Messieurs les
President, Your
juges,
Honours,
les
the
conclusions
submissions
finales faites au nom des
made
victimes.
on behalf
Je
of
vous
the
remercie.
victims. Thank you.
Thank you very much, Ms. Pele, for your submissions on behalf of the victims. We wish to assure you that we have not forgotten the victims. Our job is to balance the rights of the victims and their alleged suffering with procedural correctness, together also with the rights of the accused. And as I say, this does not mean that the victims are forgotten. I thank you all for today's submissions, that is the prosecution and the representatives for the victim, all three of you. And with that, we will adjourn today's hearing till we meet again tomorrow at 9:30 when we shall hear counsel, maybe one or two counsel or three counsel for the defense on behalf of Mr. Said. So with that, I rise the court for 9:30 tomorrow. Thank you.
All rise, veuillez vous lever.